Something unfolded inside a federal courtroom that I've almost never seen play out this fast, and I'm going to walk you through it the only way that matters. Evidence, not speculation. In the exact courtroom drama structure and voice style outlined here. It was 2006 in the afternoon when the defendant walked in like this was still a negotiation. He wasn't in cuffs. He wasn't in a cuffs. He wasn't in a jumpsuit. He was on pretrial release, dressed like a man who believed a tailored suit could function as a legal argument. Charcoal jacket. White shirt. No tie, just that deliberate, I'm casual because I'm confident look. And he wasn't some anonymous nobody. He was Evan Mercer, 46, founder of a fintech company that raised money on glossy promises and quarterly calls filled with optimistic math. The government's theory was simple. He didn't just overpromise. He lied, took investor money anyway, and then tried to cover the whole thing up once the numbers collapsed. 9 counts. Wire fraud, securities fraud, conspiracy, and the one that changes everything in federal court obstruction. That word is always the hinge. Because juries will argue about business judgment. They don't argue as much about destroying records. At 2008-7-8, the clerk called the courtroom to order. The judge took the bench and looked down at the verdict form like she already knew it was heavy. Is the jury ready to report? The foreperson stood. Madam Foreperson, the clerk said, how do you find as to count 1? Guilty. Count 2. Guilty. Count 3. Guilty. By the third guilty, Evan Mercer's lawyer stopped writing. That's a small thing. But in federal court, it's a tell. When the pen stops moving, it's because the defense has run out of future. Count 4. Guilty. Count 5. Guilty. Count 5. Guilty. Now Mercer blinked hard slowly, like his brain was trying to buffer reality. His shoulders pulled back, then forward, like he didn't know which posture to choose for a life that was splitting in half. Count 6. Guilty. Count 7. Guilty. Count 7. Guilty. Count 8. Guilty. Count 9. Guilty. 9 for 9. No split. No compromise. No, we're not sure on that one. And in federal court, a complete conviction doesn't just feel worse. It is worse. Because it closes doors. It narrows appeals. It tells the judge the jury didn't merely believe the prosecution's story. They rejected the defense entirely. Then the prosecutor stood up. And this is where the room changed. Not a speech. Not a victory lap. A motion. Your Honor, the prosecutor said, the government moves for immediate remand pending sentencing under 18 U.S.C. Section 3143, and we further move to revoke release based on violations discovered in the last 72 hours. That's the moment defendants don't anticipate, because on TV there's always a pause. There's always a recess. There's always some polite delay that lets the defendant hug their mother. Federal court does not operate on television logic. Mercer's lawyer jumped up like he'd been shocked. Your Honor, Mr. Mercer has complied with every condition for 2 years. He has appeared at every proceeding. He has, the judge raised her hand. Counsel, I'm going to hear the government. Now let me be precise about what's happening here. Once you're convicted in federal court, the presumption flips. Detention is the default unless the defense can show the person is not likely to flee, not a danger, and, depending on the case, has a substantial appellate issue. The word shall shows up in the statute for a reason. The system is designed to treat a guilty verdict as a new legal gravity. The prosecutor laid out 3 facts. 3 pillars. Clean, organized. Cold. First, a call. The government played a recorded call placed at 11:41 p.m. MU, 2 nights before the verdict, between Mercer and a private aviation broker. And Mercer's voice wasn't panicked. It was logistical. How fast can you get me wheels if I need to be out before sunrise? He asked. Not if something happens. Not if I'm convicted. He said if I need to be out. That phrasing matters. It's the mindset of a man preloading an exit. Second, money movement. At 6:17 the same morning, Mercer authorized a series of transfers totaling $312,000, broken into smaller blocks, pushed through 2 separate accounts, and then sent to a third-party platform tied to an offshore residency program. That's not paying bills. That's the type of transaction that makes a judge sit up straighter. Third, digital deletion. The prosecutor said pretrial services received a tip and pulled data logs from a device Mercer was allowed to use for work. It showed a backup had been wiped the previous weekend, not accidentally, not a glitch, manually. And here's a part that made the courtroom go still. The wiped backup included messages with a former employee and employee who testified against Mercer messages that had never been disclosed to the government. The defense attorney tried to interrupt. Your Honor, there is no proof he... The judge leaned forward. Counsel, do you dispute the recorded call? The defense attorney looked at Mercer. Mercer didn't look back at him. Mercer stared straight ahead, eyes slightly unfocused, like he was trying to pretend the courtroom didn't exist. Your Honor, the defense attorney said carefully, I have not had an opportunity to. The judge cut him off again. Do you dispute the authenticity of the recording? Silence. 3 seconds. In federal court, 3 seconds is an answer. Then the judge asked the question that ends the argument. Mr. Mercer, she said, do you have access to any passport other than the one you surrendered? Mercer's throat moved. He swallowed. He did not answer. He glanced just once at his lawyer. And his lawyer did something lawyers do when the truth is sitting in the room like smoke. He said, Your Honor, my client complied with surrender requirements at the outset. That is not responsive, the judge said. I asked whether he has access to any other passport. And Mercer finally spoke. He didn't say yes, he didn't say no. He said, I don't see why that matters right now. That line, the refusal to answer a simple custody question, was the last piece the judge needed. Because this wasn't about guilt anymore. This was about control. Mercer still believed he could steer the exchange. Judges do not allow convicted defendants to steer. The prosecutor didn't raise his voice. He didn't need to. Your Honor, he said, the government can proffer documentation under seal that the defendant obtained a second travel document through an expedited foreign citizenship process. We also have communications indicating he discussed relocating funds before the lights go out. I watched Mercer's hands. They were gripping the edge of the defense table so hard his knuckles turned white, and his right foot started tapping. Fast, uncontrolled, like his body was trying to run without permission. The judge looked down at her notes, then up at Mercer, then back down, and she delivered the line that converts a man into custody. I find the defendant has failed to demonstrate by clear and convincing evidence that he is not likely to flee, she said. I further find violations of release conditions based on credible evidence presented today. Bond is revoked. Mercer's face strained. He tried to speak something like a protest, something like a plea. The judge didn't let him. Remanded immediately. And that phrase is not metaphor. It's instruction. To U.S. Marshals moved in from the side door with the calm of people who have done this 1,000 times. Professional. Quiet. No drama. That professionalism makes it worse, because it tells you this is not a moment of emotion. It's procedure. Mercer stood too fast. His chair scraped loudly across the floor, sharp in a room that had gone silent. He looked toward the gallery where his sister had been sitting. She had been holding her hands together like prayer. She didn't move. Mercer tried to smile at her. It was a bad smile. The kind of smile your face makes when your nervous system is failing a test. The marshal turned Mercer around, hands behind his back, and then you heard it. The metallic click. Not loud, but final. I've said this before, and I'll say it again. That sound changes the temperature of a courtroom. Because it's the sound of reality being locked into place. The defense attorney tried one last time. Your Honor, we request a brief stay to allow Mr. Mercer to speak with his family and arrange. Denied, the judge said. And then, just like that, the man who walked in at 2006, dressed like a strategist, was gone through a side door before 2020. Now let me explain why this matters. People think sentencing is when consequences begin. That's not correct. In federal court, custody can begin the moment guilt is found, especially when the case includes obstruction behavior that signals the defendant doesn't respect boundaries. And obstruction is the multiplier, because at sentencing, the probation office will prepare the present tense investigation report. The PSR is where the story becomes numbers, loss amount, victims, sophistication, role in the offense. In Mercer's case, the government had argued the losses tied to his fraud totaled $18. $4 million spread across 214 investors. They also argued he was an organizer, not a passenger. That means enhancements. That means guideline math that climbs fast. And if the judge believes he deleted evidence, contacted witnesses improperly, or tried to flee, that's not just bad optics. That can become a sentencing enhancement for obstruction. meaning the same behavior that got him remanded can also add years. Here's what happens next in the real federal sequence. First, intake. Processing, property inventory, phone call, medical screening. Then, a holding unit where the defendant's world shrinks to cinder block and time. Second, detention pending sentencing. The defense files objections to the PSR. The government files its sentencing memo. Both sides argue what the guideline range should be, and more importantly, what sentence is sufficient but not greater than necessary. Third, the long road. Appeal arguments. Post-trial motions. Legal filings that take months. But custody is immediate. The system is slow with paperwork and fast with consequences. So let me ask you a question. Given a complete conviction, 9 out of 9, and then a recorded private jet call, suspicious fund movements, and evidence deletion, do you think the judge was right to revoke bond on the spot? Drop your view in the comments. I read all of them, and if you want breakdowns based on courtroom reality instead of social media hot takes, subscribe, like, and share, and tell me if you've ever watched someone go from confident to cuffed in under 15 minutes.